Today, we will present the case of Apprendi v. New Jersey. Charles C. Apprendi, a resident of New Jersey, was charged with shooting at an African-American family's home. While in custody, Apprendi made a statement, which he later retracted, that he no longer wanted the family in his neighborhood because of their race.
The court will now hear the case of State of New Jersey versus Charles Apprendi. Will the prosecution present its case?
Yes, Your Honor. The State of New Jersey charges the defendant, Charles C. Apprendi Jr., with unlawful possession of a firearm and an incident that occurred December 22nd, 1994 at approximately 2:04 a.m. In the early morning hours, Mr. Apprendi fired several .22 caliber bullets into the home of an African-American family that had recently moved into an all-white neighborhood in Vineland, New Jersey. This incident is part of a disturbing pattern. The family had reported ongoing harassment, including racial slurs directed at them from local residents.
Following the jury's determination of guilt on 23 charges related to the incident, the prosecution allowed Apprendi to enter a plea agreement to 2 counts of unlawful possession of a firearm in the second degree and 1 count of unlawful possession of an anti-personnel bomb.
Your Honor, my client accepts the charges and pleads guilty to the unlawful possession of a firearm.
Your Honor, the state accepts the guilty plea to the firearm possession charge.
Noted. Since Mr. Apprendi has pleaded guilty to the firearm charge, we will proceed with the sentencing at a later date. We are here today to sentence Charles Apprendi for the charge of unlawful possession of a firearm. The maximum sentence for this crime under New Jersey law is 10 years. However, the prosecution has indicated it will argue for an enhanced sentence under the state's hate crime statute.
The state argues that Mr. Apprendi's actions were driven by racial bias. The victim in this case is an African-American family who were subjected to physical danger and emotional distress due to the defendant's actions. Witnesses have testified that Mr. Apprendi made racially charged statements before the crime. During the arrest, he allegedly stated that he did not want the family in the neighborhood because of their race, which clearly indicates a racially based motivation for his actions.
Your Honor, my client has already pleaded guilty to the firearm possession charge and has stated that he was intoxicated at the time of the incident, not motivated by hate. There is no basis for applying an enhanced sentence based on hearsay that has not been proven beyond a reasonable doubt.
The court will hear arguments from both sides.
Thank you, Your Honor. I would like to call Officer Jones to the stand. Officer Jones, can you describe the events that transpired when you arrived at the crime scene?
When we arrived at the residence, we found evidence of a shooting directed towards the home of the victims. The neighbors reported hearing gunshots, and some stated that they had heard Mr. Apprendi shouting racial slurs prior to the shooting.
And did you recover any evidence linking Mr. Apprendi directly to these statements?
While we did arrest Mr. Apprendi with the firearm, there was no direct evidence of him using racial slurs at the scene. However, he did make a comment during his arrest indicating his disapproval of the family's presence.
Objection, Your Honor. My client has retracted that statement. This is hearsay. There's no solid proof that my client said anything racially motivated before the shooting. He maintains that his actions stemmed from intoxication at the time.
The court will not consider that statement for this enhancement.
Officer Jones, you stated that no witnesses could directly link my client to any racial remarks. Is that correct?
Yes, that's correct.
Thank you. However, I will now take into consideration the evidence regarding the alleged racial motivation for the crime. Based on the testimony and the circumstances, I find sufficient grounds to apply the hate crime enhancement. Therefore, Mr. Apprendi will be sentenced to 12 years in prison.
Your Honor, the jury didn't find me guilty of a hate crime. How can you increase my sentence based on allegations they didn't even decide?
This is unconstitutional. The court is punishing my client for a crime of which the jury did not convict him.
The court rules in accordance with state law. If you wish to appeal this decision, you may do so. Court is adjourned.
Mr. Apprendi's legal team appealed the sentence enhancement, arguing that it violated constitutional rights. In Apprendi's appeal citing a violation of the Due Process Clause, the Court of Appeals asserted that the enhancement based on New Jersey's hate crime statute is a sentencing factor rather than an element of a crime, which therefore did not need to be presented to a jury. And the state Supreme Court affirmed this decision. Now, the case has been granted a writ of certiorari at the U.S. Supreme Court, where it raised the question, can a judge impose a sentence beyond facts not found by the jury? Oral arguments in Apprendi v. New Jersey were heard on March 28th of 2000, where attorney Joseph O'Neill argued for the petitioner Apprendi, and Edward C. Dumont argued for the United States as amicus curiae, with Deputy New Jersey Attorney Lisa H. Scotchman for the respondent.
The court will now hear the case State of New Jersey versus Charles Apprendi. Counsel for the petitioner, please proceed.
Mr. Apprendi was charged with unlawful possession of a firearm and pleaded guilty to that charge. However, following his plea, the state wanted to enhance his sentence under New Jersey's hate crime statute based on alleged racial motivations that were never presented to a jury. Per the Sixth Amendment's right to a jury trial, my client's constitutional rights were violated when the lower court judge improperly utilized discretion to accept the enhancement. While our client took a plea, the question of fact pertaining to whether the crime was racially motivated was not presented to a jury, and the resulting enhancement was thus an improper sanction and clear violation of this amendment.
You are arguing that the judge's decision to enhance the sentence based on the hate crime statute violated your client's constitutional right?
Yes, Your Honor, the enhancement is unconstitutional because it punishes Mr. Apprendi for a crime he was not convicted of.
Counsel for the respondent, you may proceed.
The state argues that the evidence presented during the sentencing hearing, including witness statements and the nature of the crime, supports the judge's decision to impose an enhanced sentence. Mr. Apprendi's actions showed a clear racial motivation. As outlined in the New Jersey hate crime statute, one sentence may be enhanced beyond the prescribed maximum if acts of intimidation motivated by bias were committed. The court's determination of guilt for unlawful possession of a firearm does not negate the state's obligation to seek an appropriate sentence that reflects the severity of the defendant's actions. Under New Jersey law, the judge is supposed to determine the appropriate sentences based on all the evidence, and the enhancement is justified when the nature of the crime demonstrates prejudice.
Mr. O'Neill, would you like to respond?
While the prosecution may have acted reasonably within the New Jersey statute, the argument that Mr. Apprendi's actions were racially motivated signifies an interpretation of the bias to be an essential element of the crime in regards to the defendant's actus reus. By characterizing the defendant as having specific intent to intimidate the family given their race, the prosecution is relaying facts of the offense. When the lower court judge accepted this during the evidentiary hearing for the enhancement, thus bypassing a jury's right to determine facts, the rights of Mr. Apprendi were clearly violated.
And how does the petitioner respond?
Yes, the foundation for the judge's ability to do so lies in the precedent McMillian v. Pennsylvania. The court allowed sentencing factors found by a judge, not a jury, to increase one's sentence.
Yet, one can also invoke in Ray Winship, where the court determined that one must be found guilty of every fact of a crime using the standard of beyond a reasonable doubt, not a preponderance of evidence.
So, along the petitioner's line of reasoning, the prosecution may charge a defendant with a second-degree offense. Yet, after a jury finds guilt beyond a reasonable doubt for the offense in the second degree, can then, along with the trial judge, punish the defendant for the equivalent of the offense in the first degree.
Well, the court reverses and remands the decision.
In a 5-4 decision delivered by Justice John Paul Stevens, the United States Supreme Court found in Apprendi v. New Jersey that per the 6th Amendment's right to a jury trial and the 5th Amendment's due process clause, combined with the 14th Amendment's incorporation doctrine, any fact that enhances the sentence for a crime beyond the prescribed statutory minimum must be presented to a jury and accepted beyond a reasonable doubt. As a result, judges today cannot circumvent the right to a jury trial and increase the convicted sentence without this particular burden of proof in determining facts. Judges may still apply a prior conviction not present in one's indictment to increase a sentence,